So we're going to just go through a case law update today for our kind of mid-year breakfast briefing. Thought it's a good time to do that because this one tends to be a bit quieter just with summer holidays and things. We actually used to do this. I don't know if anyone remembers when we used to do the longer webinars. They were like, I think about 2 hours long, but we've kind of fizzled it out since. But I'm always saying to clients, while it's good that we look at statutes and we look at the Employment Rights Act, these kind of things, employment law is always evolving through case law, through what's going through the court and tribunals. So I think this will be something that we reintroduce maybe every so many months into the breakfast briefings. So picked out some recent cases that have gone through the tribunal system, tried to focus on decisions that made it to the Employment Appeal Tribunal, because for anyone who's not aware, decisions at an employment tribunal, they're not they're not binding on other courts and tribunals, but once something reaches the Employment Appeal Tribunal, that decision does become binding, so that becomes an authority at that point. So I've tried to pick out cases that have recently made it to the Employment Appeal Tribunal for that reason. So our first case is looking at offers of employment, and specifically conditional offers of employment, and just some nuances that it's good to be aware of. And that's the Cancanalapi and Lueshi Energy Systems case. So in this case, an employee was offered a fairly senior project manager role with Lueshi. And the offer letter given to him set out 3 different conditions that the offer of employment was subject to. So the first 2 are fairly standard: receipt of satisfactory references, a compliant right to work check, which is obviously a legal requirement in the UK. And the last one, which I'll ask you to bear in mind as we go through the case, is that the offer was subject to successful completion of a 6-month probationary period commencing on the start date. So upon receipt of this offer, the employee accepted and then immediately provided reference details and also the documentation needed to carry out that right to work check. Although it was noted in the case that he didn't sign the offer letter, which was prescribed by the letter itself. Now, what actually happened after that point is there was quite significant project delays. So the company approached the employee, withdrew this conditional offer, and sought to replace it with a new conditional offer. But the new offer had a new condition in it where it said that it was going to be dependent on a future notice to proceed. So that would obviously be so that they could, pull the trigger on the offer when the project delays, when they had more information. Now, what was interesting in this case is that this individual had actually already incurred quite significant costs on reliance of that original offer. It wasn't a UK national, so had booked overseas flights to come over to the UK, had started incurring those relocation costs based on that first offer. So he raised a claim to the Employment Tribunal, and that was a breach of contract claim. And the other issue he complained about to the tribunal was that he should also be due notice pay because a contract had been formed between him and the employer at the point he had verbally accepted that offer and started to send over his documentation. So they couldn't just withdraw it. So the first tier employment tribunal actually found that because that was a conditional offer, no binding contract had been formed between the 2 parties. The conditions, if you like, hadn't been satisfied, so the offer hadn't materialised into a contract. But they went a bit further to say that even if there was a contract between the parties, the employer wouldn't have been required to give any notice or pay any notice pay because he hadn't completed 1 month's service. So 1 month's service is required to be owed any sort of statutory notice from an employer. So he ultimately appealed that decision, and the Employment Appeal Tribunal actually did overturn the tribunal's decision, and they held that the original tribunal had erred in law in the way they looked at this. So for the first thing they noted is that although it was an offer letter, it had all of the kind of essential terms that you would expect to see in an employment contract. So I've picked some out there. Job title, start date, how many hours they would be working per week, what the holiday entitlement that the role attracted would be, bonus arrangements, pension provisions. So you'll see they're quite detailed for an offer letter. And if we cast our mind back, I'd ask you just to keep in mind that one of the conditions was that he was required, it was conditional upon him completing the 6-month probationary period. And what the Employment Appeal Tribunal said is that that condition really cannot be completed until employment's commenced. It would be impossible to, complete that condition prior to employment because you need to actually start and then start work and start demonstrating your skills and things through that 6-month probationary period. So they coined this a subsequent condition. And if we look back to the way the offer letter was structured, hold on, I'll actually go back. It was these 3 conditions. They didn't carve out or separate this last one about the successful completion of a 6-month probationary period from the other 2. So the Employment Appeal Tribunal took that to say, without that distinguishment, all 3 should be treated as subsequent conditions. And that had the practical effect of meaning that as soon as he accepted that offer, a contract was formed, an employment contract had already formed between the employer and the employee. That meant that the breach of contract claim was actually successful in the Employment Appeal Tribunal, whereas it wasn't in the Employment Tribunal. The next thing they had to look at was notice. And the issue was that in that offer letter, there was no agreement on what notice would be. So what the Employment Appeal Tribunal did is that they implied a reasonable notice period and said that where there is no notice period, that's the correct route. Now, based on the seniority of the project manager position, the impact of relocation, they deemed that 3 months' notice was reasonable. So the employer was ordered to, a declaration was made that the contract had been formed, it had been breached, and that 3 months' notice pay was due to this employee. So I suppose this one's just a kind of helpful reminder that, have a look at your job offer template letters. What have you got on as conditions on there? Just because something's conditional, it doesn't mean that there's no contract being formed. So if you're in a position where you plan to withdraw an offer, it's worth taking a look at the original offer just to make sure there's nothing that could catch you out. If there is anything a bit more complex about it, it's not always a bad idea to take advice. Particularly looking at things that might be a subsequent conditions. So do you have anything in your offer letter which is subsequent, which can only really be demonstrated or fulfilled after they commence employment, in which case it's very likely that there will already be a binding contract in place, even without employment start date having been commenced. And then another helpful note from the EAT in this case that if there isn't an express notice provision, they can just imply a reasonable one by looking at things like the seniority of the position, the skills involved, just the full factual matrix of that role. So our next case, we're moving on topic swiftly this morning because our next case actually focuses on collective consultation. And again, this is one that reached the EAT, and I think there's a helpful reminder to go through this one because one of the things the Employment Rights Act has done is extend the financial compensation that can be awarded for collective consultation claims, but we'll look at that towards the end. So in this case, the employer was facing financial difficulties, and as a result, an administrator was appointed on the 2nd of May 2023. So if we just keep that date in our head, the 2nd of May. So when they came in, they looked at staffing and they immediately dismissed 15 non-essential staff to, who weren't instrumental in operations to make an immediate cost saving. Now, at that point, the administrators were really banking on a sale materialising. They were hoping that they would be able to sell the business and the rest of the workforce would have their job saved essentially. But unfortunately, in those kind of pivotal days between the 2nd of May and the 5th of May, that sale fell through. So on the 5th of May, the whole bulk, the majority of the remaining workforce was dismissed. Now, employees brought claims to the Employment Tribunal alleging that the employer had failed to comply with the statutory duty to collectively consult. Now, the key dispute in this case, hopefully you'll be aware that in certain redundancy situations, collective consultation obligations kick in, and the kind of test for that's put there. So if an employer is proposing to dismiss 20 or more employees within a 90-day period, enhanced consultation obligations kick in. So that would be, electing representatives or using trade union representatives if you have them, and you're tied into, depending on the numbers, minimum consultation periods. You have to let the RPS know, all these types of things. So they were looking at on the 2nd of May, so that original date when the administrators came in, were they proposing to dismiss 20 or more employees within a 90-day period, and were these obligations triggered, so payments owed? Now, what the Employment Tribunal found here is that the dismissals were in two separate groups. So you had the 15 dismissed on the first day when the administrators came in, 2nd of May, and then the rest, which was a number over 20, on the 5th of May. So when looking at the 2nd of May, only 15 dismissals were being proposed. So you'll see there the point above, that sits under the 20 or more within a 90-day period. So what the Employment Tribunal did was award protective awards to those dismissed on the 5th of May, because they were in the larger group with over 20 or more employees, but they didn't give any sort of protective award to the employees in that first 15-person group. Now, this was again appealed to the Employment Tribunal, and the employees in that first 15-person group said that the tribunal had, applied the law wrong. And the Employment Appeal Tribunal agreed with the employees in this case. They said that they got the legal test wrong, and where they went wrong was really splitting it up and looking at it in that way. They failed to properly assess whether on that first day when the administrators came in on the 2nd of May, there was already a proposal formed that could result in 20 or more dismissals within that 90-day period. And what they said is that if everything was really relying on this sale, and it was instrumental in the viability of the business in those really kind of pivotal few days between, then there was already a proposal to make 20 or more redundant on the 2nd, and because it was all pinging on that sale. So the EAT confirmed that it's not, possible to avoid, if you like, collective consultation obligations, those enhanced obligations by, separating redundancies in separate tranches, quite literally in the way that was done in this case. And the duty is triggered, just as a reminder, once an employer proposes to dismiss 20 or more employees in an establishment over a 90-day period. So again, just an interesting one. I think firstly interesting because the Employment Tribunal got the law quite materially wrong in that first pass when it went through the Employment Tribunal. And also just a good reminder that if you are making redundancies, it's just important to do an assessment on whether or not collective consultations kicked in. So is there anything, in the mind of the business or, senior leaders that would give rise to further redundancies in the 90-day period? What kind of dismissals have taken place? in the 90 days before that. So really make that assessment to work out if your collective consultations obligations kick in. And again, not a bad one to take advice on. And then just a note at the bottom that's more important than ever now, because the maximum protective award that can be made has effectively been doubled. So in this case, the employees were all awarded 90 days pay. If that happened now, they would be given 180 days pay per employee. So yeah, could be expensive if it was on top of other claims, with a number of employees. And at the moment, I'm trying to think if we've ever done a breakfast briefing session just on collective consultation, obligations and the rules. I'm not sure that we have. So if any employers or anyone on the call thinks that would be a good topic, I could do one on that. I'll add it to my list. And our last case, again, a useful one because it went to the EAT and serves as a good reminder on protected conversations, conduct when carrying out protected conversations and settlement agreements. So for anyone on the call who maybe hasn't, had to utilise a settlement agreement or a protected conversation before, a protected conversation is a kind of statutory creation. So it's governed by Section 11A of the Employment Rights Act, and it allows an employer to have like a pre-termination discussion with an employee, where you can propose an enhanced financial package for them to leave the organisation. And it has statutory protections. So if the conversation is made under that piece of legislation, whatever's discussed is inadmissible in an ordinary unfair dismissal claim. So that's the usual vehicle to initiate, someone leaving the business via a settlement agreement. That tends to be where that would be proposed. So in this case, there was a kind of proposed redundancy situation, and the employer, to kind of short circuit the need to, place a lot of people at risk and go through that lengthy redundancy process, had a protected conversation with this employee. Now, the employee didn't accept the potential settlement offer, later alleged that, there was pressure being placed on him, that he was being given deadlines and not given enough time to fully consider the offer. Anyway, the process went on and he was eventually dismissed by reason of redundancy, and he brought claims to the Employment Tribunal of unfair dismissal, and also unlawful deduction from wages and unfavourable treatment as a part-time worker for other issues in that redundancy process. Now, the kind of discrete part of this case that we'll discuss is just the findings that they made in relation to the protected conversation that took place. So initially, the Employment Tribunal found in favour of the employer, who argued that everything that was discussed in that protected conversation was protected under the piece of legislation I mentioned, Section 11A of the Employment Rights Act, so should be inadmissible in evidence. He shouldn't be able to refer to it in tribunal, it shouldn't be in any documentation. And the Employment Tribunal found in favour of that. The employee did argue that the manager's conduct throughout the meeting was improper, and they looked at certain comments made. But the Employment Tribunal, on balance of the two sides, evidence presented, found that there was no improper conduct. And as a result, all evidence of that protected conversation was essentially scrubbed from the tribunal case record. So say you have your bundle of evidence, anything related to that would have been redacted, any notes of these conversations would have been removed. It was just completely, eradicated from the case. This point was appealed to the Employment Appeal Tribunal, and again they disagreed with the way the Employment Tribunal had interpreted this, and said that they'd erred in law. The issue that they said the tribunal had is that they applied the protection under that piece of legislation across all of the employees' claims. So if you remember, he claimed ordinary unfair dismissal, but he also claimed unfavourable treatment for being a part-time worker and unlawful deduction from wages. So from removing everything from the court documents, the tribunal evidence bundle, this was applied to all the claims. But the EAT confirmed that this protection only applies to ordinary unfair dismissal claims. It shouldn't have been applied to the unlawful deduction from wages and less favourable treatment for being a part-time worker claims. The other thing that the EAT kind of noted in this case is that while they looked at the comments made in the context of the protected conversation, they didn't really examine in any great level of detail the other allegations made by the employee. So things like, being pressured in terms of how long he had to consider the offer, and just generally feeling the timescales were rushed and that he was under pressure. So again, I think just a good reminder that, quite often employers might think the protected conversation label or, having conversations under the guise of a Section 11A protected conversation just give a kind of veil of protection where you can be quite frank, but it's really important to remember that these protections only apply to ordinary unfair dismissal claims. So if you have any sort of claims, discrimination claims in particular, the types of claims that were in this case, unlawful deductions, the content of that protected conversation can still be admissible in evidence. So I suppose that's just a good reminder and a good note to all, just to make sure that, when you're having these conversations, you're not seeing anything in them that you wouldn't be comfortable being in a tribunal bundle, that, you'd be uncomfortable giving evidence on in front of a judge, that we're comfortable with everything we're saying, no improper comments, making sure that if you're proposing to have one of these conversations, you're building in appropriate timescales. So ACAS do actually have really good guidelines on settlement agreements and proper conduct, and they suggest 10 days from the written terms being provided. So there's a kind of minimum guideline there, if you like, but making sure that time's built in and there's no pressure. And I suppose one good thing is if you have a particularly contentious one, that might be making you nervous, it might be worth pre-preparing a conversation script. If you have access to legal services, having that script reviewed ahead of time, just to make sure there is no comments in it that might, fall foul of any rules or anything in there that could be higher risk. But I suppose the message on this is just to be, cautious that these conversations can be admissible in other claims, as was reminded by the EAT in this case. So that's all we have time for this morning. Just a very high level gallop through and a good mix of topics there. I'll probably have a bit of whiplash after that. But as I say, I'm happy to hang on if anyone has any questions. And you'll get a copy of these slides. I tried to put a lot of detail in the slides because we were going quite fast, in case you want to actually read through the cases in more detail.